Parliamentary Acts and Legal Framework in India. Prevention of Food Adulteration Act 1954. 1954 में बना ये Prevention of Food Adulteration Act. The Prevention of Food Adulteration Act was introduced in 1954. 1955 में force में आया. This law aims to ensure quality and safety of food items consumed by public and preventing adulteration of food products. It defines food adulteration, specifies food standard, and establishes penalties of violations. The Act empowers the authorities to take strict measures to maintain food purity, and it lays down penalties for selling adulterated food. Protection of Civil Rights Act 1955. The Act was enacted to prevent exploitation and discriminations of SC/ST, particularly the practice of untouchability. Article 17. Fundamental. It makes all punishable offences related to civil rights violation cognizable and triable summarily, meaning that certain cases are directly handled by court without the need of prior investigation. मतलब ऐसे केसेस कोर्ट द्वारा डायरेक्ट हैंडल किया जाए बिना किसी प्रायर इन्वेस्टिगेशन के. द प्रोटेक्शन ऑफ सिविल राइट्स एक्ट वर्क्स अलोंगसाइड शेड्यूल्ड कास्ट एंड शेड्यूल्ड ट्राइब्स. प्रिवेंशन ऑफ एट्रोसिटीज एक्ट 1989. मतलब ये प्रिवेंशन ऑफ मतलब SC/ST या प्रिवेंशन ऑफ एट्रोसिटीज एक्ट 1989 के साथ डायरेक्ट काम करता है. ठीक, टू इंश्योर right of marginalized communities. 1989. Protection of Women for Domestic Violence Act 2005, enacted to protect women from domestic violence. This act extends to all women regardless of their marital status. Key provisions क्या है? It provides a comprehensive definition of domestic violence, including physical, emotional, and economic abuse. The Act allows women to seek relief, protection orders, and residence orders from the court. This Act was enforced on 26 October 2006. The Act allows women to seek relief, protection orders, and residence orders from the court. The Act allows women to seek relief, protection orders, and residence orders from the court. Criminal Tribe Act 1871. The Criminal Tribe Act, enacted during British colonial rule in 1871, identified certain communities as criminal based on their traditional occupation and lifestyle. Though it was repealed after independence, it left a legacy that still influences social and legal frameworks. ठीक है. Scheduled Tribe Prevention of Atrocities Act 1989. Act enforced on 30 January 1990 aimed to prevent atrocities against scheduled tribes. Section 18 of the Act prohibits anticipatory bail for the accused. Investigation must be conducted by police officers not below the rank of Deputy Superintendent of Police. मतलब DSP वो डायरेक्ट इसको इन्वेस्टिगेट करेंगे. A special court is established for speedy trials of offences under this act in every district. सारे डिस्ट्रिक्ट में. Hindu Marriage Act 1955 and Hindu Succession Act 1956. These acts were designed to codify Hindu personal law and provide legal safeguards to women, especially regarding marriage, inheritance, and property rights. Key features क्या हैं? The Hindu Marriage Act deals with marriage registration, the grounds for divorce and maintenance. The Hindu Marriage Act deals with marriage registration. The Hindu Succession Act provides for the inheritance rights of both male and female heirs in Hindu families. ये दोनों मेल और फीमेल दोनों लोगों को हक देता है प्रॉपर्टी में. Right to Information Act 2005. Purpose: the Right to Information Act was introduced to enhance transparency and accountability in governance by giving citizens the legal right to access information held by public authorities. The Right to Information Act was introduced to enhance transparency and accountability in governance by giving citizens the legal right to access information and held by public authorities. The Act allows citizens to request information from public authorities with few exceptions, जैसे national security. The Act allows citizens to request information from public authorities with few exceptions. The Act allows citizens to request information from public authorities with few exceptions, जैसे national security. It made it mandatory for government bodies to disclose certain categories of information, thus fostering transparency. Important case Namita Sharma versus Union of India. Case is related to RTI Act, where Supreme Court emphasized the importance of transparency in governance. RTI Act 2005. National Green Tribunal 2010. The National Green Tribunal was established to handle environmental cases and ensure enforcement of environmental laws. It provides an expeditious mechanism for the adjudication of environmental disputes. The tribunal is empowered to review environmental clearances granted for projects. ठीक. Panchayat Extension to Scheduled Areas Act PESA 1996. Panchayat Extension to Scheduled Areas Act. PESA is a significant law that aims to provide greater autonomy and governance right to tribal communities residing in scheduled areas. Key feature: the Act empowers Gram Sabhas, village council in tribal areas, to play an important role in decision making, particularly in matters related to land use, natural resources, and traditional governance structure. Beside RTI Amendment Act 2019. The 2019 amendment of RTI Act modified the provision related to tenure of Chief Information Commissioners and Information Commissioners at both central and state levels. The tenure was reduced, a term prescribed by central government which is usually 5 years. Commission of Sati Prevention Act 1987. To curb the practice of sati, the burning or burying alive of widows. Provisions declares the abetment or glorification of sati as a criminal offence. Provides for punishment including imprisonment and fines. Context क्या? Enacted after the infamous Roop Kamar Sati incident in Rajasthan in 1987. The Act aims to prevent and punish the glorification of sati, thereby safeguarding the dignity and rights of women. RTI and Mazdoor Kisan Shakti Sangathan. Role of MKSS, Mazdoor Kisan Shakti Sangathan, an Indian grassroots organization instrumental in advocating for right to information. Contribution क्या है? Pioneered social audits, bringing transparency in government expenditure. Its efforts were crucial in the enactment of RTI Act 2005, which empowered citizens to access information from public authorities. Significant achievement: the MKSS movement highlighted corruption in rural development projects, emphasizing the need of transparency. Chief Election Commissioner, Information Commissioner and Informationer Commissioner Amendment 2019, detailed amendment. Earlier, the CIC and ICs had a fixed tenure of 5 years. The amendment empowered the central government to notify their terms of office. It also changed the salary and terms of services, which can be now be determined by government rather than being on the par of chief election commissioner. Critics argued that this amendment undermines the independence of information commissioners, making them more vulnerable in government influence. जब ऐसा हो जाएगा तो भाई वो तो होगा ही होगा. National Green Tribunal established in 2010. Legal basis the National Green Tribunal Act 2010. Objective, effective and expeditious disposal of cases relating to environmental protection and conservation of forests. The NGT deal with environmental cases laws under Water Act 1974, Air Act 1981, Water Act 1974, Air Act 1981, Environment Protection Act 1986, Forest Conservation Act 1980, Wildlife Conservation Act 1972, Water 1974, Air 1981, Environment 1986, Forest 1980. The tribunal's order can be challenged only in Supreme Court. अब ये जो एनजीटी का है इसका जो ऑर्डर है वो सिर्फ सुप्रीम कोर्ट में ही चैलेंज किया जा सकता है. पंचायत एक्सटेंशन टू शेड्यूल्ड एरियाज एक्ट पेशा 1996 enacted under Article 243M of the Constitution to extend the provision of panchayat to scheduled areas. Importance of tribal governance empowers Gram Sabha to manage natural resources, resolve dispute and approve plans and projects. Ensure the right of tribal communities over minor forest produce and control over local market. Significance क्या है? Ensures self-governance through traditional Gram Sabhas, promoting participatory democracy in tribal region. Right to information, fundamental legal right. Article 19(1)(a) of the Indian Constitution guarantees the freedom of speech and expression, which indirectly includes the right to information. 19(1)(a) of the Indian Constitution guarantees freedom of speech and expression, which indirectly include the right of information. Empowers citizens to question and hold the government accountable. Plays a vital role in promoting transparency, especially in welfare schemes. ठीक है. And public works. Key cases related to RTI: Namita Sharma versus Union of India 2013 addressed the qualification and tenure of information commissioners, directed the inclusion of judicial members to afford transparency. Central Information Commissioner versus State Information Commissions defined the jurisdiction of the CIC and SICs in handling complaints and appeals under RTI Act. ठीक. In which year was the Prevention of Food Adulteration Act? 1954 में फूड एडल्ट्रेशन एक्ट आया था 1954 में. To ensure food safety by preventing adulteration of food product, it came into force in 1st June 1955. ठीक. The act defines food adulteration, specific food safety standards and prescribed penalties for violations. Objective: to protect consumers from hazardous and adulterated food. फूड सेफ्टी. अच्छा, ये फिर क्या हुआ? द एक्ट वाज लेटर रिप्लेस्ड बाय फूड सेफ्टी एंड स्टैंडर्ड एक्ट 2006, इंटीग्रेटिंग मल्टीपल लॉज रिलेटेड टू फूड सेफ्टी. फूड सेफ्टी एंड स्टैंडर्ड अथॉरिटी ऑफ इंडिया वाज एस्टेब्लिश्ड अंडर 2006 एक्ट. फूड सिक्योरिटी FSSAI जो है 2006 एक्ट के अंदर ही रेगुलेट होता है एंड सुपरवाइज फूड सेफ्टी. Recent amendments: the FSSAI now monitors food quality through initiatives like Eat Right India. All offences punishable under Protection of Civil Right Act 1955 are cognizable and summarily triable. बिल्कुल सही है. Section 15 of Protection of Civil Right Act 1955, all offences under act are cognizable. मतलब पुलिस can arrest without a warrant.
मतलब प्रोटेक्शन ऑफ सिविल राइट 1955 में बिना वारंट के पुलिस अरेस्ट कर सकती है। एंड समरेली ट्रायबल मतलब क्विक ट्रायल विदाउट लेंदी प्रोसीजर, और ट्रायल भी बिना लेंदी प्रोसीजर पूरा किया जा सकता है। टू इंश्योर स्पीडी जस्टिस इन केसेस ऑफ डिस्क्रिमिनेशन अगेंस्ट शेड्यूल्ड एंड शेड्यूल्ड ट्राइब्स एंड कास्ट। कॉग्निजेबल एंड नॉन वेलेबल नहीं, समरेली ट्रायबल है, मतलब जल्दी जल्दी पूरा वो हो जाएगा। करेक्ट एज पर द समरेली ट्रायबल। Offences are tried under the Protection of Civil Rights Act 1955 by the courts of ये जो है फर्स्ट क्लास जुडिशियल मजिस्ट्रेट फर्स्ट क्लास ये जो है वो तय करते हैं। ठीक है, जुडिशियल मजिस्ट्रेट फर्स्ट क्लास। जुडिशियल मजिस्ट्रेट फर्स्ट क्लास इज एम्पावर्ड टू ट्राई केसेस अंडर द प्रोटेक्शन ऑफ सिविल राइट एक्ट 1955। In Uttar Pradesh, Chief Judicial Magistrate or Judicial Magistrate First Class function as special courts of these offences। उत्तर प्रदेश में जो फर्स्ट क्लास के मजिस्ट्रेट रहेंगे वही वो करेंगे। पर्पस टू इंश्योर प्रॉम्प्ट लीगल प्रोसीडिंग्स फॉर सिविल राइट वायलेशन। सेशन कोर्ट नहीं, हैंडल मोर सीरियस ऑफेंसेस। सेशन कोर्ट्स हैंडल्स मोर सीरियस ऑफेंसेस। जुडिशियल मजिस्ट्रेट फर्स्ट क्लास करेक्ट एज पर द एक्ट। सेकेंड क्लास नहीं, दीज कोर्ट्स हैंडल लेस सीरियस केसेस। चीफ जुडिशियल मजिस्ट्रेट, बट जुडिशियल मजिस्ट्रेट फर्स्ट क्लास इज स्पेसिफिक आंसर। ऑल द पनिशेबल ऑफेंसेस अंडर प्रोटेक्शन ऑफ सिविल राइट्स एक्ट 1955 आर कॉग्निजेबल एंड ट्रायबल। समरी सही है। कॉग्निजेबल एंड नॉन कंपाउंडेबल मतलब ऑल ऑफेंसेस एक्ट और कॉग्निजेबल मतलब बिना वारंट की गिरफ्तार किया जा सकता है। ट्राइबल समरी मतलब तेजी से काम होगा। एंड नॉन कंपाउंडेबल मतलब आउट ऑफ कोर्ट मतलब आउट ऑफ कोर्ट सेटलमेंट नहीं हो सकता, जो होगा कोर्ट में ही होगा। कॉग्निजेबल पुलिस कैन अरेस्ट विदाउट वारंट। ट्राइबल समरी क्विक ट्रायल्स बाय जुडिशियल मजिस्ट्रेट फर्स्ट क्लास जुडिशियल मजिस्ट्रेट के अंतर्गत वो आएगा। नॉन कंपाउंडेबल द केसेस कांट बी सेटल्ड आउट ऑफ कोर्ट। Under the Protection of Civil Rights Act 1955, under the Protection of Civil Rights Act 1955, all offences are cognizable और punishable with imprisonment and fine both। बेलेबल नहीं है, कंपाउंडेबल भी नहीं है, मतलब बिना वारंट की गिरफ्तारी हो सकती है। कोर्ट का प्रोसीजर जल्दी जल्दी होगा। फर्स्ट मजिस्ट्रेट जो होंगे वो मतलब देखेंगे चीज़ों को। पनिशेबल विथ इम्प्रिजमेंट एंड फाइन बोथ, इम्प्रिजमेंट जेल और फाइन दोनों लगेगा। ऑफेंसेज अंडर दिस एक्ट इज आर कॉग्निजेबल एंड पनिशेबल विथ बोथ इम्प्रिजमेंट एंड फाइन। सेक्शन 15(1) of the act specifies cognizable nature and section 10(1)(a)(1) mention imprisonment and fines as modes of punishment। Cognizable है bailable, incorrect as offences are not always bailable। Compoundable incorrect as they are not compoundable। Punishment and imprisonment and fine both। If any person refuses admission to any hospital, dispensary or educational institution on the ground of untouchability, then under which section of Protection of Civil Rights Act 1955 shall he be punishable। अगर हॉस्पिटल में अनटचेबिलिटी को लेकर मतलब कि कहीं भी जगह एडमिशन नहीं मिल रहा है तो सेक्शन 5 ऑफ सिविल राइट एक्ट 1955 के तहत उनको क्या किया जाएगा, मतलब सज़ा मिलेगी। Section 5, if anyone on the ground of untouchability denies admission to any hospital, dispensary or educational institution, they are punishable with imprisonment of 1 to 6 months and fine ranging from 100 to 500। To protect the right to equality, Article 14, and prevent discrimination based on caste and social background। Section 4 किससे relate करता है? Relates to prohibition of preaching and advocating untouchability। relates to the prohibition of preaching and advocating untouchability. मतलब अगर कोई एडवोकेट भी कर रहा है अनटचेबिलिटी को. Section 5 specifically deal with denying access to public places. Section 6 pertains the denial of entry and places of worship. Section 7 deals with enforcement of disabilities related to untouchability. The Protection of Civil Rights Act 1955 was an extension of Article 17, abolition of untouchability, to the Constitution. The Act penalizes practices that perpetuate untouchability, reinforcing directive principles aimed at social justice. Judicial precedents: State of Karnataka versus Appa Balu Ingale 1993 में reiterated the importance of abolishing untouchability in public places. People's Union for Democratic Rights versus Union of India 1982 emphasized the significance of social justice through legal enforcement. Under which one of the following section of the Protection of Civil Rights Act 1955 has power of state government to impose collective fine been provided? Section 10A. Section 10A of Protection of Civil Rights Act 1955. This section empowers the state government to impose a collective fine on a community or area where offences under the act are frequent. मतलब collective fine भी लगाया जा सकता है वहाँ पे. Objective: to deter the recurrence of offences related to untouchability by holding the community accountable. Historical insight: this provision was influenced by collective fine system introduced by British in India. Section 10 deal with abatement of offences. Section 10A deals with collective fines. Section 14 deals with offences by companies. ठीक है. The protection of civil rights extends to whole India. Section 1(2) of the Protection of Civil Rights Act 1955. The Act extends to the entire territory of India. Post Article 370 abrogation 2019. The Act is now applicable to Union Territory of Jammu and Kashmir as well. This ensures uniform protection against untouchability across whole India. The Protection of Civil Rights Act 1955 extends to whole of India. The Act extends to the entire territory of India, including Union Territory. Earlier, Jammu Kashmir had its own laws due to Article 370, but after the abrogation, central laws including this Act are applicable. Under which of the following section of the Protection of Civil Rights Act 1955 has offences by companies been provided? Section 14 specifies the liability of companies for offences committed under the Act. Who is held responsible? The director, manager or secretary of the company who was in charge at the time of offence, to ensure accountability of corporate entities upholding civil rights. Section 10 deal with abatement of offence. 12 deal with presumption of courts by presumption by courts in certain cases. Section 14 offences by companies. Section 16 act to override other laws. 1955 civil rights. Who is held responsible for the offences committed by companies under the Protection of Civil Rights Act 1955? तो डायरेक्टर, मैनेजर या सेक्रेटरी कोई भी होगा, सारे लोग. इफ एन ऑफेंस इज कमिटेड बाय ए कंपनी, द पर्सन इन चार्ज एट द टाइम, डायरेक्टर, मैनेजर और सेक्रेटरी, इज डीम्ड गिल्टी एंड लायबल फॉर पनिशमेंट. इंश्योर्स दैट कोऑपरेट bodies are not exempt from accountability. When the court under Section 12 of the Protection of Civil Rights Act 1955 shall presume that the offence is committed on the ground of untouchability. When the court under Section 12 of the Protection of Civil Rights Act 1955 shall presume that the offence is committed on the ground of untouchability. तो वो होगा व्हेन इट रिलीज टू मेंबर ऑफ शेड्यूल कास्ट ओनली। ठीक है, when it relates to the member of scheduled caste only. Section 12 specifies that courts shall presume that the offence is committed on the ground of untouchability unless proven otherwise, especially when it involves scheduled caste members. मतलब अगर अगला नहीं प्रूव कर देता है तब तक ये माना जाएगा कि ये अनटचेबिलिटी का मामला था, प्री एज्यूम कर लेती है कोर्ट। Offence is committed on the ground of untouchability unless proven otherwise, especially when it involves scheduled caste member. शेड्यूल कास्ट मेंबर पे अगर वो होता है तो अनटचेबिलिटी विल नॉट कंस्टिट्यूट एन ऑफेंस व्हेन एक्यूज एंड कंप्लेनेंट बिलोंग टू सेम सोशल ग्रुप। अगर सेम सोशल ग्रुप पे हैं तो ये नहीं मामला बनेगा। सेम सोशल ग्रुप द एक्ट डज नॉट अमाउंट द अनटचेबिलिटी अंडर एक्ट। Charitable trusts do not exempt untouchability. Use of finery irrelevant to the context. Competency of that does not negate the offence. Same social group as per the provision. The Protection of Civil Right Act 1955 was originally called the Untouchability Offence Act 1955. It was amended in 1976 to expand the scope and rename it, focusing on eradication of untouchability. Article 17 of the Indian Constitution abolishes untouchability and practices in any form. Importance judgment. State of Karnataka versus Appa Balu Ingale 1993. Supreme Court upheld the conviction under PCR Act, emphasizing that any form of untouchability is unconstitutional. A court can presume that any act constituting an offence was committed on the ground of untouchability if such offence is committed in relation to a member of scheduled caste. As per Section 12 of the Protection of Civil Right Act 1955, if an act constituting an offence under this act is committed against a member of scheduled caste, the court shall presume that the act was committed on the ground of untouchability unless the contrary is proved. To ensure stronger protection for Supreme Courts against SSC scheduled castes against discrimination based on untouchability, this section reverses the burden of proof to some extent, empowering the victim. Scheduled craft, the provision specifically mention SCs, under which one of the following section of the Protection of Civil Right Act 1955 has protection of action taken in good faith been provided. Article 14A. Protection of action taken in good faith. Section 14A provides protection for action taken in good faith. It states that no suit or other legal proceedings shall lie against the central government or state. No suit or legal proceedings shall lie against the for anything done or intended to be done in good faith under this act. Objective to protect officials from legal consequences when actions are performed in good faith. To uphold the act encourages effective enforcement without fear of litigation. अच्छा, good faith में Article 14A. Which one of the following pair is not correctly matched? Hindu Marriage Act 1955 सही है, Hindu Succession Act 1956 सही है, 73rd Constitutional Amendment Reservation of seats for women in election of local bodies in urban area नहीं Sati Prevention Act 1987 सही है, 73rd Amendment Act 1992 pertains to rural local bodies पंचायत and mandate 1/3 reservation for women. अर्बन को लेकर नहीं है, अर्बन को लेकर 74th है. Reservation for women in urban local bodies municipalities is provided in 74th Constitutional Amendment Act 1992.
Hindu Marriage Act 1955, Hindu Succession Act 1956, 73rd Amendment, reservation in urban areas, Sati Pratha Act 1987. Match list one. अच्छा Indian Divorce, Indian Arms Act 1878. Indian Arms Act 1878 regulate the acquisition and possession of arms. Indian Arms Act 1878 regulates the acquisition and possession of arms. Royal Title Act 1876 allowed Queen 1876 allowed Queen Victoria to adopt the title Empress of India 1876. Indian High Court Act 1861 established High Court in Calcutta, Mumbai और Madras. Indian Divorce Act 1869 governs divorce and marriage law for Christians in India. इंडिया में क्रिश्चियंस के लिए इंडियन आर्म्स एक्ट 1878, रॉयल टाइटल एक्ट 1876 और मतलब इसमें विक्टोरिया जी को एम्प्रेस ऑफ इंडिया कहा गया. इंडियन हाई कोर्ट एक्ट 1861 एस्टेब्लिश्ड हाई कोर्ट इन कलकत्ता, मुंबई और मद्रास. इंडियन डाइवोर्स एक्ट 1869 गवर्न डाइवोर्स एंड मैरिज लॉ फॉर क्रिश्चियन इन इंडिया. ठीक है. द प्रोटेक्शन ऑफ वुमेन फ्रॉम डोमेस्टिक वायलेंस एक्ट. Protection of Women from Domestic Violence Act came into force on 26 October 2006. ठीक. Enacted in 2005, came into force on the 26 October 2006 to protect women from domestic violence and provide relief, including protection order, monetary relief, and custody order, etc. Additional insight recognizes various forms of abuse जैसे फिजिकल, वर्बल, इमोशनल और इकोनॉमिक. ठीक है. विच ऑफ द फॉलोइंग इज नॉट ए सोशल एक्ट. मीसा एक जो है सोशल एक्ट नहीं. ये मेंटेनेंस ऑफ इंटरनल सिक्योरिटी एक्ट 1971 इनेक्टेड टू मेंटेन सिक्योरिटी ड्यूरिंग इमरजेंसीज. मीसा एक्ट. Repealed in 1977. It is not a social act as it deals with preventive detention and internal security, unlike other acts which address social evils. Anti-Dowry Act, social act against dowry practices. Prevention of Civil Rights Act, social act to eradicate untouchability. Prevention of Immortal Traffic Act, social act against human trafficking. Good faith principle, often seen in many acts, providing immunity to government action taken with honest intent. Often seen in many acts, providing immunity to government action taken with honest intent. Social legislation, these acts aim to address social issues and protect vulnerable groups जैसे SC, ST, women. Constitutional amendment, remember the difference between 73rd and 74th amendment regarding reservation पंचायत and municipalities. ठीक है. तो इतना वो होता है, बाकी अगले में करते हैं. थैंक यू, बाय बाय.